So a firm offer occurs when a seller promises in a signed writing to keep an offer for the sale of goods open for a period of time. And again, does not apply to non-merchant sellers. So this rule of offer revocation is going to depend on whether the seller is a merchant or a non-merchant. A firm offer, as I said, is limited. It's irrevocable for the time stated in the offer, but if no time period is stated, then it'll stay open for a maximum of 3 months. The offeree does not have to pay any consideration. When you see that on your test, look to see, is there a signed writing from a merchant? If so, there is no obligation on the part of the offeree to pay any consideration, to give anything of value in exchange for holding that offer open. Take up acceptance. Acceptance is the other aspect of mutual assent. Acceptance of the offer is necessary for mutual assent, necessary for the contract to exist. Now, the UCC changes some common law requirements for valid acceptance. The rules provided by Article 2 for accepting an offer are not as rigid as the common law rules. Again, the UCC wants there to be a contract in a way that the common law does not. So acceptance, and what do we do to accept an offer, is different under the UCC than it is under the common law. If the offeror does not clearly provide for a method of acceptance, meaning maybe you can insist on acceptance in writing only, the UCC allows an offeree to accept the offer in any reasonable manner. And under the UCC, acceptance can be effective even if the terms of the acceptance do not match the terms of the offer. We're going to see about what we do when that occurs. So the UCC does away with a very important aspect of the common law, which is known as the mirror image rule. Under the mirror image rule, a contract is formed if the response indicates a definite acceptance of the offer. If the acceptance mirrors the offer, then a contract is formed. And it must be exact. And if there are any changes included in the acceptance, then the acceptance becomes a rejection and a counteroffer. If you say, I offer to sell you my computer for $500, and I said, yes, I will take you up on that offer as long as you include the carrying case. Even though I said, yes, I accept your offer, in fact, I have changed the rules. Well, under the UCC, that acceptance can change. So we look to see, did the parties act as if they have a contract? And if they did, the UCC will treat it as a contract. Now, acceptance of an offer to buy or sell goods must be made in any reasonable manner and by any reasonable means. In fact, a party can accept an offer simply by promising shipment of goods or by shipping conforming goods. If I send an email to a furniture supplier, I am revamping my law office and I need 30 desk chairs, the furniture supplier can simply ship the goods, and under the UCC, that would count as a valid acceptance. If the shipment is of goods that are non-conforming, goods that don't match the terms that we bargained for, that will not change the fact of an acceptance. There will be an acceptance, but there is a simultaneous breach. So a prompt shipment of non-conforming goods is both an acceptance and a breach by the seller. This brings us to the problem that we in the law refer to as the battle of the forms. Now I'm going to do another video in which I'm going to show you some images of the forms and talk about this in more detail. But essentially, when we are talking about the battle of forms, we're talking about conflicts that occur because the parties are using pre-printed forms or templates. Now, the two forms that often arise, that often cause this battle, this conflict, it would be, first of all, a purchase order. A purchase order is an order, it's an offer sent from the buyer to the seller, usually offering to purchase goods according to certain terms and conditions. The seller will often send an invoice term and an invoice form which will contain the terms from the seller's perspective. If the purchase order and the invoice form have conflicting terms, which we know as the battle of the forms, the UCC provides guidelines on how to resolve the dispute. In battle of the forms cases, the UCC provides that a document can constitute acceptance even though it states terms that are additional to or different from those offered by the offeror, and those additional terms may become part of the sales contract if certain conditions are present. So how do we treat these additional terms? Treatment of additional terms in an acceptance depends, again, on whether the parties are merchants or non-merchants. If one or both parties are non-merchants, a contract is formed according to the terms of the original offer. So if either party is a non-merchant, the contract is formed and the changes are simply disregarded. The contract is formed according to the terms of the original offer. So in a battle of the forms case, if one of the parties to a sales contract is not a merchant, the contract is formed according to the terms of the original contract. The contract is considered accepted. This is an acceptance, even though it does not mirror the offer, like the common law requires. But the additional terms are simply not part of the contract. The party who has sent or has accepted, whether it's the buyer or the seller, their additional changed, supplemented terms are disregarded. In the case of merchants, however, how do we address additional terms involving merchants? If both parties are merchants, then the additional terms automatically become part of the contract unless certain conditions apply. If the parties are both merchants, the contract is formed automatically, including the additional terms, unless the offeror has expressly and clearly limited acceptance to the original terms. Meaning, in our purchase order, the buyer states, this is the offer. Any purported changes to the terms are not accepted. Acceptance is only possible on the original terms. If it is a material change, which means an important change, important alteration that diverges significantly from those contained in the original offer, then the additional term do not become part of the agreement. And finally, if the offeror raises an objection to the additional terms within a reasonable time period, then the additional terms do not become part of the contract. So if there are additional terms proposed by the offeree in an acceptance, those additional terms become part of the contract unless one of these three things has occurred. The offeror limited acceptance only to the original terms, or the additional term is a material change that diverges significantly from those contained in the offer, or if the offer or raises an objection within a reasonable time period. The knockout rule is what occurs if the terms of the purchasing order, the purchase order, are different from the terms in the invoice firm. Conflicting clauses knock each other out, and neither clause becomes part of the contract. Courts then will look to the UCC's gap filler provisions to supply the missing term.